between the nostrils.
Welcome back to the Law and Crime Network. I'm Heather Hansen, and we're continuing to wait for the courtroom to go back live in the case against Donald Smith, and specifically with respect to the death penalty part of that case. I want to talk to my next guest about that, and he's got a lot of interesting information for us. His name's Gary Gerstenfeld. He's a criminal defense attorney here with us via Skype. Good afternoon, Gary.
Hi, it's good to be with you.
Good to have you here. Let's talk a little bit about what's going on in this Donald Smith case, because now we are in the death penalty part of this case, a part of the case that is one thing that juries don't often see. You know, we talk a lot about death penalty cases, but there aren't as many of them as it may seem for people who watch TV. What do you think we can expect from the defense's case, which is about to start in just within the half an hour, most likely?
Well, right now what the defense has to do is show that there are mitigating circumstances that would warrant against the death penalty. And they're limited by statute as to what specific issues they can raise. But they're going to try to show that there's some sort of a mitigation that would warrant Mr. Smith being spared the death penalty and getting life without possibility of parole.
And what type of mitigation do you expect? We know we're going to hear from medical witnesses, and one of the witnesses was being held on voir dire and questioned in front of the judge before the lunch break. It seems he's going to testify to the effect of cocaine on the brain. Do you think we'll see other witnesses like that testifying from a medical perspective?
Absolutely. The only real argument that really can be made in this case, because the limitations of what you can raise in this sort of mitigation argument is basically things like the man has some sort of a mental disability of some sort, and so they have to raise that issue. Now, normally voluntary intoxication would not be a defense in a criminal case, but in terms of looking for medication, that is an issue that can be raised.
Well, and also, I'm interested to see whether or not there's going to be some testimony about the long-term effect of cocaine in the brain. So perhaps Smith wasn't actually using cocaine the day that he kidnapped and brutally attacked and murdered Cherish Periwinkle, but maybe he had done it in the past, and some sort of connection the defense is trying to make there, which I think will be interesting, not just for this case, but in other criminal cases going forward. Do you think that they'll try to sort of get in some interesting brain science in order to try and get at least one juror to cling on to that?
One of the challenges they're going to have with that is you have to remember Mr. Smith had only been released from jail or prison 3 weeks earlier. So he's only been out for a little less than a month. But the mental health issue is a strong issue to argue. And you have to remember when Melissa Nelson was running in her campaign, she raised the issue of mental health problems. She's done a lot in her office to try to address mental health problems with people who've been charged with crimes. Her office is taking that into consideration in some of the death penalty cases they're considering now.
And when you talk Melissa Nelson, just for our audience, that's the prosecutor?
Yes, she's the prosecutor in the case. She was just elected in 2017, and this is her first murder trial.
Yeah, I mean, big.
First death penalty case, I should say.
Right, a lot on her shoulders, and a lot of everyone who's working on this case. The public defender who's representing Donald Smith as well. They're all, a lot of eyes on this case, a lot of attention to this case, especially in light of everything that's gone on with the death penalty there in Florida of late. Do you think that all of the back and forth with the Supreme Court and the Florida death penalty will have any impact on these jurors? I'm sure that at least some of them have been aware of it because it's been covered so heavily in the news.
Right. So what's happened now is that you have to have unanimity among the jury in order to find somebody guilty to give the death penalty. Then they make a recommendation to the judge, and the judge makes the ultimate decision. But the judge can't make that decision. The big change in the law now is that the jury has to make a unanimous decision of death. So you have to get all 12 jurors to decide beyond a reasonable doubt that the death penalty is warranted. The toughest thing the defense is going to have is coming back against what Melissa Nelson said in her opening statement, which is very powerful. Every mother's greatest nightmare becomes Periwinkle's reality. And that's going to be the strongest issue that they're going to have to combat.
Yeah, without a doubt, Gary, and that kind of leads me to my next question. We saw the only witness that the prosecution called today was another young woman, now a little bit older, who is one of the victims of Donald Smith. They didn't call Rain Periwinkle again. They didn't call any of the other family members. Do you expect to see the prosecution put on a rebuttal case here?
No, I do not. In the prosecution's case, they really didn't hold back any punches. They really showed exactly what happened. You have to remember, even the medical examiner at one point had to take a 5-minute break because she broke down. I think that was legitimate. I don't think that was planned. I think this was just a reaction, watching the jurors crying, some of them not able to even look at the pictures. The prosecution did an excellent job in presenting their side of the case. And you have to remember, there's a parallel with Mr. Smith and the Jimmy Rice Act, which you have here's a kidnapping, a sexual battery, and a capital murder by a guy who's got a rich history going back 4 decades of committing all kinds of sex crimes.
Let's back up a little bit, because that's something you were telling me about off air that I, not being from Florida, was not as tuned into. So the Jerry Rice Act is a statute there in Florida that says what?
Well, the Jimmy Rice Act basically requires civil commitment if there's a finding that a person having completed their sentence for a sex crime is a high-level risk that if they're released back into the community, they're going to pose a threat. As a matter of fact, Mr. Smith was actually subject to that. He actually was housed in what they call the Civil Commitment Facility in Florida. He claims through his mother, who gave an interview, that he didn't get any treatment at all. As a matter of fact, Florida still has that problem. When they release people today, even from civil commitment, there's no follow-up. The only program available at all is a charity organization called Miracle Village, which is very limited and only to a small group of people. Most sex offenders in Florida are, frankly, living in a tent in the woods someplace, getting no treatment whatsoever.
Well, and that's awfully scary, as we see in this case. Do you think that's going to be part of the defense's case here, that he was not given the help that he needs? Yeah.
Absolutely. A couple of things that he pointed out through his mother. One was that he didn't want to have a vehicle when he got released because he was afraid if he had a vehicle, something bad might happen. He also went to a hospital asking for help, and he was denied help. And this was, again, he was only out of jail for about 3 weeks before this incident occurred, so it wasn't like there was a long time. But there was nothing following his release from treatment. And he says, according to him, that he didn't receive any treatment while he was actually in civil commitment.
Yeah, I mean, listen, as much as abhorrent as these crimes are and as disgusting as they are, that is certainly, at the very least, lost opportunity. Because had he gotten some treatment, and when he said he didn't want a car, I mean, that is, gosh, awfully telling. Do you think, I know what I think about this, and we can go back and forth, but do you think we'll hear from Donald Smith's mother in the defense part of this case?
I do not. She's not listed as one of the witnesses, and it's not helpful. She did give an interview before, and she talked about demons. The argument I think can be made is that he wasn't suffering from demons. I think the argument the government has pretty much laid out is that he sort of is the demon.
Right. That's a really good analogy and a really good point. I think that the defense's position is going to have to be that the illness is the demon and that Donald Smith is as tortured by that demon as anyone else. And that's going to be very difficult. You know what? We do have court feed. We're going to take you live to the court as soon as we have some sound there. I don't know if you can see it, Gary, but our audience is seeing Donald Smith there. Now, when they tried the guilt part of the case, he was in civilian clothes. Now he is in jail clothes. Do you think that was a decision on his part, and if so, a strategic decision?
Absolutely. So now what the defense needs to show, and this is Julie Schlacks, what she needs to show is, look, if you give him life without parole, this is his life. He's going to be wearing a jail uniform. There's no pretense now putting him in civilian clothes. His guilt's already been determined by the very same jury. Then it's now determining on whether or not, death is appropriate or life without parole. So at this point, yeah, you want to cast him already in chains. You want to show that he's not getting out, that he's not a danger to the community anymore, that he's going to be locked up no matter what the jury does. No other children are going to be subject to any victimization by him.
Yeah, and that is effective because it does make a very different picture than him in his suit and tie looking like he's going out to hunt for other girls. Which I've got
the glasses on top of his head. Actually, I thought it actually made him look better. I like the glasses on his head. He didn't look like such a creep. So yeah. I thought it was a good idea. But
there's some things that he did. Now, I have to ask you, Gary, because it seems like you have some specific insight into this court and these players. The defense's opening statement, where she said she was going to cross-examine Rain Periwinkle, and pretty much that was all she was going to do. And then within moments, when Rain Periwinkle got on the stand, decided not to cross-examine him, in large part because Donald Smith told her not to. What did you think of that? And what do you think the strategy was? We were all shaking our heads and trying to figure out what was going on.
Sure. Well, okay, so there's no question, and I think that it's fairly simple that Ms. Schlax gave up the fact that, yeah, this case was one where, the evidence is overwhelming. I mean, it truly was. I mean, this was a walk well done on the part of Ms. Nelson. She did a very good job of presenting all the evidence very systematically. I thought the medical examiner did one of the best jobs I've ever seen of any medical examiner, and there was a great deal of precision in the prosecution's case. So what was that crazy opening statement, now looking back on it? Well, believe it or not, there is a mitigation argument that you can make, and this is going to sound really, really bizarre, and it may, frankly, make your viewers even more upset to hear it, but here's what it is. A mitigation is that if the victim participated in the event that ultimately led to what is a capital murder case subject to the death penalty, hold on, if the victim participated in it, then that's an argument for mitigation. So the argument I think that the defense was making is that, yeah, look, the little girl, she's 8 years old, she didn't participate, but her mother did. Her mother, by being so trusting and naive and getting into this vehicle and riding off with a stranger with 3 children, young children in the car, that is such a reckless act that was in her way participating in the event. But if we don't have victimization by proxy, and the prosecution, their case isn't weakened by the defense pointing out that the mother is especially vulnerable or especially easily victimized, that she's the perfect target. In fact, all that does is makes Mr. Smith, in my view, look even like a greater creep. So in the end, I think that their opening statement, the defense's opening statement, rather backfired. But I understand where she was going. She was trying to show some sort of mitigation, and again, mitigation by proxy, which again didn't work. And she didn't do the cross-examination. How are you going to cross-examine this woman? There's nothing that you can say. I think probably that was a smart move.
Gary, I have to interrupt you. Your insight has been fabulous, and I want to thank you so much. We're going to go live to the courtroom because we are back in the courtroom. Hopefully I'll be back to talk to you some more about some testimony as we go through this afternoon.
Okay.